afternoon, good afternoon, good afternoon. Welcome to another session on accent litigation. My name is Oluwatosin Isaac, and today, as you all know, we are bringing you another interesting topic in the legal world, in the legal field. Things you need to know. They say ignorance is not an excuse. Ignorance is not an excuse. You ought to know the law. You ought to know how the law works, how it operates, your rights, and everything as far as is related to you. Yes. So today, in the spirit or in the bid of abolishing legal illiteracy, we are bringing another interesting topic to you, and we are talking about judgments, court judgments. The last week we talked about what to do after judgment, right? Something relating to judgment. So we'll continue that. It's not like a series, but it's more like a series. But it's not really a series like that. But we are still in the same line of thought. So today we are talking about how to enforce court judgments, and specifically we'll be dealing with writ of Fieri FaciaT. I hope I pronounced that correctly. Writ of Fieri FaciaT, yes. Probably you've heard of it. Probably you've seen it somewhere. Probably you've actually been engaged in it, like you were party to the writ application and the rest like that. But we'll just talk about it briefly and just briefly. So now, first of all, I want to share this story with you. There was a case I handled. All thanks to my principal. There was a case I handled, and this client was indebted to somebody, so running into millions of naira. It was a failed investments gone wrong, and my client could not pay up. He could not pay back, and the other party was aggrieved. They needed his money, money, sensitive issue, money, and he sued my client to court. Yes, my client actually admitted that he's owing the money and he wishes to pay. It's just that he doesn't have the means to pay the money. That was what led to the lawsuit in the first place. So the court, he admitted that he was owing. The court gave the order, gave the judgment, gave the ruling that my client should pay the money, indebted. And when we were leaving court that day after the judgment, the question my client asked me was, barrister, so what's the next thing? That was what he said. I mean, the court has given judgment. The court said I should pay the money. What's the next thing? I don't have the money to pay. What's going to happen? What's the next step? What am I going to do? So that's what we are going to talk about today. Now, it is the human nature. Generally, the human nature is such that they won't sit to the enforcement of judgments. Now, when judgment is given by a court of competent jurisdiction, it is meant to be effected immediately. I mean, if the court pronounced judgment, the judgment takes effect immediately. So whatever order has been given, any party that is obliged to carry out that order should do so with immediate effect. However, human nature, we might not want to do it, or might not want to carry out the judgment. I might think, okay, fine, the court has given the judgment, that's all to it. Yes, that is not all to it. Yes, the court has given the judgment, but that's not all to it. There is more to it, and that's where enforcement of judgment comes in. Enforcing judgment or enforcing court judgment means that what you are doing something for the judgment to take effect. You want to see the manifestation. Now, before I proceed, I want you to know that there are two types of judgment. There is the declaratory judgment and there is the executory judgment. Now, when we talk about declaratory judgments, it's just judgments where you don't need to do anything, where parties don't need to do anything. It's just the court pronouncing or making a declaration of something. Okay, we want the court, okay, maybe like a fundamental right action now, and the court declared that the applicant was denying its fundamental rights. The order of the court is this: the court holds that the applicant was denying his fundamental rights. He was falsely imprisoned. It was this. The court has declared it that the applicant's fundamental rights has been infringed upon. That is a declaratory judgment. You don't need to do anything. Yes, it's binding on both parties. Both parties know that, okay, fine, one party is at fault, one party is illegally imprisoned somebody, denying the other party of his fundamental rights. So, and the court has pronounced it so, yes, it is an infringement of a fundamental right. We have pronounced it, understand? Or probably, let me use another example. There is a contract between two parties, and somebody is claiming, a party is claiming that there is no contract. There is no contract, probably no acceptance, or the terms of a contract or a valid contract is not available, or the terms of a valid contract has not been added to. And goes to the court for the court to, clarify it. And the court says, okay, fine, based on the evidences, based on everything before me, I can say that there is a valid contract. Or I hereby hold, or I declare that there is a valid contract and party A is liable, blah, 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 like that. So, such judgment is declaratory. The court has declared it that there is a valid contract. So, you don't need to do anything concerning that one. But if the court goes further and say, okay, fine, based on the fact that there is a valid contract, A is liable to B to pay the sum or so and so amount. Now, that is another judgment. That is an executory judgment. It means that what? The court has declared there is a contract, declaratory. Furthermore, there is still an order again. That's okay, fine. Because there is a contract and B has reneged on it, or it did not fulfill its part, B is liable to pay the sum of 2,500,000 naira to A. That is declaration. That is executory. Meaning that what? Party B has to do something. You understand? He has to do something, pay something, or move something, or do something to B. That is executory. So there are different kinds of contracts. So when it comes to enforcing court judgments, you enforce judgment that are executory, judgment that you need to do something. Because when you talk about enforcement or execution means that what you have to make, make the judgment come into effect. We have to see it. That's okay, this is what the court said and we are doing it, or we are not doing it. Sometimes it will be an omission that don't do it. Okay, there is a judgment that there is a restraining order restraining Mr. So and so from having access to the children, or from having access. That's also executory. It means that what Mr. A is not supposed to do it. He's not supposed to go 10 meters or 10 feet, 10 feet with party B. So that is understand. So execution can be you to do something, or you're not supposed to do something, like that. But just know that there is always an action or inaction. Yes, action or inaction. Yes. So I hope you understand the difference between declaratory and executory. So I said that a judgment is meant to take effect immediately, but the general human nature might want to delay it, or might want to overlook it and not want to do anything about it. So that is where enforcement procedural rules comes in. Yes, enforcement procedural rule comes in, and these laws, the laws are in place to ensure that whatever judgment is given, it is adhered to and it takes effect. It's not just the court speaking into thin air. It's not the court speaking into thin air and just the court has spoken like that. No. So these laws are there. They are in place to ensure that what judgment is given and judgment is adhered to. Everybody stick to what has been given. So the laws applicable, we have the Sheriff and Civil Process Act, we have the Judgment Enforcement Rules, and we have the Rules of Courts, and we also have the Constitution. These are the laws that are in place to ensure that what the enforcement of judgment is seen to. So I explained earlier that there are two types of judgment, declaratory and executory. Now for executory judgments, where you have to do something, where you have to enforce it, yes, you enforce executory judgment because you have to make it come into effect, like I explained earlier. So one of the ways of enforcing it is by writ of Fieri. God, I really hope I'm pronouncing this thing well. It's also known as writ of FIFA. Yes, writ of FIFA. So pronounce it as writ of Fifi. Anyways, it's called the writ of Fieri, also known as writ of FaciaT. Now, what is this writ all about? This is like a common method of executing judgments. Let me use the story I shared earlier as a case study. Now, how does writ of FaciaT apply? I told you that, excuse me, I told you that the court has given judgment, right? And the court ordered my client to pay the money. Let's say 2 million naira, just for example, 2 million naira. He doesn't have the money to pay. He doesn't have the money. What will the other party do? In this case, my client is called the judgment debtor, while the claimant, the person claiming money, is called the judgment creditor. Not because necessarily because they are owing money like that, but it's just the terminology used: judgment creditor and judgment debtor. So what would the judgment creditor do in this case? If the judgment debtor is defaulting and is refusing to pay the money, what will the judgment creditor do? The judgment creditor will come to the court and make an application before the court, an application for writ of FaciaT. This writ of FaciaT. This writ, when issued, it's more like the aim is to levy execution on the properties of the judgment debtors. The properties of the judgment debtors. It will be seized. It will be seized by the sheriff. It will be seized and it will be sold. I hope we're getting it. So the judgment creditor will come to court, probably with his lawyer, to make an application before the court that a writ of that, my lord, the judgment debtor, since when the court has given judgment for the judgment debtor to pay his money, he has not been forthcoming. My lord, we make so an application, we bring an application before this honorable court and bring this court to grant an order of FaciaT for us to levy execution against the judgment debtor, like that. The judgment debtor will come to court, make an application that this writ should be levied, issued against the judgment debtor. Once the court grants this order, it is giving authority to the sheriff of the court to gather the properties of the judgment debtor. Now, properties here can be movable or immovable, but the first they will target is the movable properties, chattel's properties. So they'll levy execution against the movable properties. They will seize it, they will sell it, and once they sell, aside now, they can seize all the properties except now some properties a sheriff cannot seize. He cannot seize his clothes, his clothing, his apparel. He cannot seize that. He cannot seize his beddings, what he used to sleep, and he cannot seize his working tools, his tools for work, his working tools or equipment, whatever it is he uses to work and make a living. Those are exceptions. You cannot seize those. But aside that, you can seize every other thing: fridge, television, appliances, just name it. Apart from clothes, beddings, and your working tools, a sheriff can seize every other property. What is the aim of seizing this thing? They will seize it and they will sell it. Once they sell it, they will use it to what? Pay the judgment creditor. To see to it that the proceeds from the sale has been able to pay the debt. Now, in the event that when they've seized all these properties, and yet it's the money, the proceeds gotten is unable to balance or pay the debt of, then they move to the immovable property, which is landed properties or houses. Immovable properties, you know what they are, right? Properties that cannot be moved: land, house, hotels, anything, any other properties like that. So they will sell it and ensure that the judgment creditor is paid as at when due. So this is basically what they do. And when they sell these properties, maybe movable or immovable, and there is balance, they've settled everybody, they've settled the auctioneer, they've settled the debt, the judgment creditor, and there is still a balance. The balance will be returned to the judgment debtor. But the aim is for the judgment creditor to enjoy the success of his litigation, which is the judgment. So once it gets settled, if there is a balance from the proceed, they return it back to the judgment debtor. So basically that is how we enforce judgment. But I also ask a question, in a situation where by we have seen cases whereby people don't have properties. Not everybody have properties. No immovable properties. That one is out. Okay, we look at the movable properties. This person does not even have. I mean, you enter his house and his house is practically empty. What are you going to do in that case? How are you going to get your judgment? How are you going to get your money? I'll leave that question to you to answer until the next time, next session, then we'll address that. So I said that the writ of FaciaT, it's an application, so you bring it through a motion or notice with affidavit and a written address explaining why you need the court to reissue a writ of FaciaT. So basically that is all about a writ of Fieri FaciaT. Yes, writ of Fieri FaciaT. I think I've covered everything. What else? Yes, and yes. So that is all about it. Next week we'll be talking more on other ways to enforce judgments. Like I said, writ of FaciaT is just one method. It's just one method, and it's the most common method. I mean, it's the easiest. Those that are in charge of, now you're not the one going to the judgment debtor's house to go and seize his property. You all need to come to the court, probably through your counsel, and file the application. Once the court grant the order, there are people called the sheriffs of the court. They are the ones that do things like this. They are the sheriffs that serve processes, they serve court orders. Those people that normally come to your house and knock, go, who is at home? There's court paper for you. You understand? I don't know if you have experienced it before, but those are the sheriffs, and that's their duty. They are also the ones that, you understand, when the court has already given an order for a tenant, it's very stubborn tenant that refuses to pay his money, and the court, they've served him notice to quit, they've served him owner's intention, they've taken him to court, he has not given any reason, he's not even given any good reason why he's going to pay his money. Very, very stubborn tenants, you understand? So it can get to a stage whereby the court will order the sheriff to go and throw out his properties, throw everything out. I've experienced that thing, man. It's not a good sight. It's not a good sight. People should stop owing landlord money and stop being stubborn. It's not good. It's not really a good sight. I mean, they threw this man's property out with his wife and children and everything. Like, they threw it out and they locked the door. They locked it. So those people that do things like that are called the sheriffs of the court. So the sheriffs of the court are still the same person that will go to the judgment debtor's house and seize his property and sell it eventually to pay up the judgment creditor. And I said it is not all the properties they seize. They don't seize the apparels, they don't seize beddings, and they don't seize his implements for trade like that. So okay, I have something here. So there's something also important to note. Seized property cannot be sold until the expiration of 5 clear days from the date of the seizure. That means when the judgment debtor's property is seized, they don't sell it until after 5 days, or except it is a perishable, something that can spoil, then they sell that. But if it's not, it is until the expiration of 5 clear days before those seized property will be sold. So basically that is all about that. And for the immovable property, you need the leave of the court. You need the permission of the court to sell somebody land. The sheriff of the court cannot go and seize somebody land and just sell like that. You need the leave of the court. The leave of the court must be first obtained before it can be done. So that's one thing. That's the beauty about law. There is always process. There's always procedures. There are always rules that guide us. Don't just do things anyhow like that. Don't do things anyhow like that. So basically that is all about enforcement of judgments, the writ of Fieri FaciaT. Next week, we should be talking about garnishing proceedings, which is another another way to enforce judgment. So when if you are someone that got judgments in favor, judgment was given in your favor, and you're looking for how to enforce it, definitely the best way is to talk to a lawyer. Yes, the best way is to talk to a lawyer. You can't do these things on your own unless maybe you are acquainted with the procedures of the courts, the rules of the courts, and the rest like that. But the best thing is to get a lawyer and ensure that you enforce your judgment in the right way and enjoy the success of your litigation. So till next time, my name still remains Oluwatosin Isaac, and I'll see you in our next session. Don't forget to like, don't forget to comment, don't forget to share, and don't forget to drop your contribution, or perhaps you have a question, you can just drop it and we will attend to it. So until next week,